Let me introduce myself. My name is Csaba. I'm from Budapest, Hungary, and I'll introduce myself in more detail in just a minute. And I have my two colleagues with me, Sebastian Bechtel from Germany and Summer Kern from Austria. And we're going to have a presentation on new resources on access to justice. This is a bit of a mysterious title. Definitely we'll talk about resources where you can get information about access to justice development, but also we'll talk about findings of the compliance committee, new ones that shape the access landscape, that shape the access landscape recently. A few technical information. This session is recorded, so if you don't agree with this, please let us know. Definitely, then in that case, we'll try to fix that your comments are erased, or your presence is somehow hidden. We don't have a question and answer separate box, so actually you can send your questions here in the regular chat box to the right of your screen. If it's not open, then in the bottom you can find the icon, the chat icon, and if you click on that, then this sidebar for the questions and answers will appear. I'll be collecting the answers during the two presentations of my colleagues, and there is going to be a discussion session after the two presentations. So there's going to be time at 11 o'clock, from 11 to 11:30 to answer the questions. The purpose of the presentations is to help the users to get more information, how to use the access rights stemming from the Aarhus Convention, and I hope they will be useful. They will include information about not only about findings of the compliance committee, but also our interpretations, which I hope will be a good basis for our debate and a discussion at the end of this side event. So let me introduce myself in a little bit more detail to put my role into a bit of a context. I'm working as a public interest environmental lawyer since 1994, so it's 27 years, it's a lot. And we just talk with my colleagues that we are dinosaurs or fossils here, which I deny, definitely. We are young in heart. And I'm working and leading a public interest environmental law office in Hungary called EMLA. And I'm also coordinating a network of similar law offices in Europe, which is called Justice and Environment. And let's start with my presentation, which is a kind of an introduction and an overview of available access to justice resources. Given the importance of this presentation, definitely it's going to be shorter than the following ones, which will go into detail regarding findings of the compliance committee. So I'm going to share my screen. And start the presentation. I hope it's okay. Okay. So the project which I'd like to talk about briefly was managed by Client Earth, and I think we have to know what Client Earth is, although most probably you've heard this name already and you're familiar with its contribution to the development of access rights implementation. So it is an NGO which is using the power of law to protect people and the planet. That's the mission statement, and it has offices in London, Brussels, Warsaw, Madrid, Berlin, and Beijing, and USA also, which makes it quite unique and special. And it has working relationships in over 60 countries in Europe, Asia, Africa, and the Americas. I mentioned that I work for Justice and Environment, which is confined to Europe compared to Planet Earth. We have 14 member organizations and we cover 14 countries, 13 EU countries, plus we are also present in North Macedonia. And our mission is to use our legal expertise and experience to improve EU environmental laws, both legislation and their implementation for the benefit of the environment and people across Europe. In 2007, from 2017 to 20, we ran a project which was called Education and Awareness Raising of Legal Professionals on Environmental Law and Access Rights. It has a abbreviation EARL, and it has a website. You can find the link on this slide. I guess the slides will be available later, so you will see. You will be able to go to these links and find the resources afterwards. And it covered 9 countries: Austria, Belgium, Estonia, France, Germany, Hungary, Poland, Slovakia, and Spain. And while basically the project was about holding presentations and trainings and discussions and workshops in all these 9 countries to train the legal professionals on access rights, it also produced the lasting resources and replicable resources. There are a number of resources that are available online still. The major product of the project was a guide to access to justice in European Union law. I may sound biased, but I think that so far this is the most comprehensive collection of both Court of Justice and Compliance Committee judgments slash findings, respectively, in this topic. It is also updated. It was updated in 2020. So its 21 edition includes already the latest findings. Each country which participated, except Belgium, created a country toolkit to guide the members of the public how to apply their access to justice rights. In 3 selected countries, Estonia, Hungary, and Poland, we created interactive platforms where it's kind of a decision tree, where in a question and answer format, the user can just go online and the questions lead him or her to the solution of the access rights problem, be it information, participation, or justice. We created public interest environmental lawyer database. It was so popular that even countries were interested which were outside the scope of the project. So currently we have more than 100 lawyers in the list covering 15 EU member states. And during the course of the project, we produced online newsletters, which are also available. We also have replicable resources, which are not available online. Well, if anyone is interested, we are very happy to share the experience and the know-how we accumulated during the project. We had 57 training events in 9 countries. We held 12 online webinars and we had an online conference. We were actually very sad because we wanted to have a big Brussels event with high-profile people present and fancy surroundings and catering and etc. And then the COVID-19 came in the middle, so we had an online conference, which allowed actually almost 3 times as many participants to participate. And we had high-profile people there on the panels, and I think that was quite a successful event, and it's still available online. And because it coincided with the first draft of the amendment of the Aarhus regulation by the Commission, it was quite timely. Then the event was kind of quasi dedicated to discussing the processes on the EU level. That would be really unfair just to mention these resources which are available on these civil society websites without mentioning the European Commission, DG Environment and DG Justice efforts to spread knowledge on access to justice in environmental matters in the form of so-called e-justice fact sheets that are available on the European e-justice portal. Last year, 54 national experts, 2 from each EU member states, worked on preparing these fact sheets, reviewing it in a number of rounds, and verifying its content, also via communication back and forth with the respective governments. And these contain in-depth knowledge on access to justice, the available remedies in information, participation, and other like infringement of national environmental law cases. They are available right now only in English, and the other EU language versions will be later available. Again, I suggest you visiting the e-justice portal of the European Commission, which is otherwise a very rich source of information, but now it's much richer with environmentally relevant access to justice rules. I thank you for your attention, and after this short presentation, I think we can go into the merits. I stop sharing and let me introduce our first presenters. So it's going to be Sebastian. Am I right, Sebastian? Right, you're the first one. Okay, so no ladies first rule. I'm sorry, Summer. Sebastian is from Germany and he works for Clienters as a lawyer in the environmental democracy team. And previously he worked for the Secretariat of the Aarhus Convention. And Sebastian, the floor is yours.
Yeah, thank you very much, Chava. I hope you can hear me and see my screen. Very good. Okay, so I will be speaking about one of the outputs that Chava has just mentioned, and that is the Guide on Access to Justice in European Union Law. I will, of course, not cover all of the content of the guide, but I wanted to just flag the general structure and talk about some highlights, some cases that might be of specific interest, as well as some more recent Court of Justice cases that have come out only this year. So this will be kind of the structure of my presentation, and then I will finish speaking about the amended EU internal review mechanism on EU level, so the new possibility to challenge acts of EU institutions and bodies that relates to an Aarhus term case C32. So the guide, just as an overview, it is, as our whole project was intended, really for people that use access to justice right or work with them on a daily basis or quite frequently. So lawyers, public authorities, judges, and NGOs. And we've updated it this year in February 2021. So it doesn't include everything, because everything that happened afterwards is not included, including a number of findings that Summer will be speaking about later today. And it's available online. And if you are at the meeting of the parties next week in Geneva, we will be also bringing some hard copies. So it's divided in 4 chapters in access to justice in the member states, structured according to the provision of the convention, according to Article 9, Article 9, 1, 2, 3, 4, and 5, and I will go through that in a moment. And then we have a final chapter regarding access to justice in relation to EU institutions and bodies. So that's exactly the internal review mechanism that I just mentioned. So going through these chapters, just to give you a bit of an overview, the first one relates to the implementation of Article 9.1, so the access to information rights. If you make a request for information, environmental information, and you are refused, the possibilities to go to court and to challenge that refusal. This is, I think, the shortest chapter, but it does involve a number, I think, of important topics. One, the case law of the court related to information on emissions, because information on emissions is supposed to be more publicly available and override other exceptions. The definition of public authorities, which has become an issue, I think, recently, in particular, in UK and Ireland, but also in other jurisdictions where special powers and control, special powers are given to non-classical public authorities, but these authorities then must still provide access to environmental information on request. So there's some discussion about that. There's some discussion on costs, which we still encounter in our work as well as an issue in certain jurisdictions, such as, for instance, in our recent work in Germany, we see that there's still quite some disparities in the costs applied to access to information requests. And finally, there is the issue of time. And I think this is of particular importance in the context of access to environmental information requests, because access to information is always, or almost always, if not always, time sensitive. And it's, I think, a challenge in still every jurisdiction that if you challenge a refusal, it takes a lot of time to get a decision. And there have been two recent findings on that as well from the Aarhus Compliance Committee that I wanted to quickly flag, which is C96 and C141, which are very new as well. And they relate to delays from the Officer for Environmental Information in Ireland and the European Ombudsman. Chapter 2 concerns public participation rights. So essentially the implementation of Article 9.2. So the possibility to go to court with relation to specific activities that are also connected to the public participation rights under Article 6 of the Aarhus Convention. So under EU law, we have an implementation of this right under specific directives, namely the Environmental Impact Assessment Directive, the Industrial Emissions Directive, the Seveso III Directive. So this is covered in the guide, but it's not limited there. So that's important to note. There's also standing rights based on the case law, based on Article 6.1b in relation to appropriate assessment under the Habitats Directive, but also water permits. In this case, it would equally seem to apply, even though that has not been addressed yet by the Court of Justice in relation to waste permits. So this is kind of what the guide covers. And again, some highlights of that chapter without going into too much detail. A big issue continues to be standing, of course, in relation to individuals and NGOs. We will later be hearing from Summer about case C137, which relates to formal criteria for NGOs, which is a very recent compliance committee finding on this. Standard of review, even though left to the procedural autonomy of the member states, is also still delimited by the applicable EU legislation, and that is explained. And one point that I wanted to particularly highlight is the scope of review, because I think there's been some confusion around this recently, I think based on the case law, because there's two in the most recent case in Northeast Thailand and Laos. These are both came out within the last few years. There are statements by the Court of Justice that Article 9.2 of the Aarhus Convention is related to enforcing public participation rights, and therefore the scope of review of these challenges is equally delimited. But at the same time, the court always tests whether there are also a violation of EU environmental law in the sense of Article 9.3, or also other violations of environmental law based on national law would also fall under 9.3. So I think this is an important point that we also raise in the guide. If we are talking of a challenge that is based on the Article 9.2, one always has to think about both of these provisions together. It cannot be that a challenge related to an environmental impact assessment is in its scope delimited to violations of public participation requirements. This is not the Court of Justice case law. It always is necessary that an applicant is able to allege other violations of the EU environmental law. And also this is maybe something for the discussion later on. Then coming to my first case highlight of that is very new, a very recent case, Stichting Varkens, from the beginning of this year, establishes some important principles. And that's why I wanted to talk about it in a bit more detail quickly. The first thing that it establishes, it was a Dutch case, and it was brought by individuals and NGOs, and there were some questions as to standing, but in particular that I want to talk about right now in relation to preclusion. So the requirement that an applicant needs to participate in the public participation phase preceding a specific permit in order to be later be able to go to court. And the court has made a very clear statement there that in relation to Article 9.2, this is not permitted under EU law. It cannot be possible that this is made a precondition for access to justice. And at the same time, though it stated that under Article 9.3, this can be possible under certain conditions. So even though, as the court says, this is a limitation to the right of effective remedy under Article 5.2 of the Charter, 52 of the Charter, it can be possible if the rule is formulated in a proportional way. So in the Netherlands, the rule was formulated in a way that if the applicant could not be not have reasonably participated, he or she should still be able to go to court if member of the public concern. And then the Court of Justice said this rule is okay. But at the same time, the court, it says nothing about material preclusion, for instance. It doesn't address the point if can an applicant be limited to the specific points that he or she raised during the public participation phase. And this is a rule that some of you may know is still applicable in Germany, for instance. So this is quite an interesting case in relation to the fact that it really, in particular under 9.2, establishes this very clear rule that was kind of hinted before in Tiergarten, but it was never 100% clear. There isn't a possibility for preclusion. And then it kind of establishes a possibility for that under 9.3, but not without limits. Then turning to chapter 3, this now concerns Article 9.3, so contraventions of environmental law. Those of you familiar with the convention, you know this is an additional right that goes beyond specific activities and that allows members of the public to bring claims where they find there has been a contravention of environmental law. Under EU law, this is the provision that remains rather not implemented. There is an implementation. This is the Environmental Liability Directive, but it only applies to very specific contexts, namely environmental liability. There was a directive proposal at one point that would have implemented this provision horizontally, but it has failed. And the Commission has now committed itself to implementing it by way of introducing specific provisions in sectoral legislation. That's based on the communication that's here. But as the situation stands, the only way that this area of law is developed is by way of preliminary references to the Court of Justice. And there's quite a lot of case law at this stage. So it's not the case that there are no requirements. And that's, I think, something that we spend quite a lot of time in the guide on to explain how has this case law developed and what do we see are the requirements that flow from it. Again, I don't have the time, unfortunately, today to go through all of the details of that, but just again to highlight the case law relates to different kinds of decision making, plans, permits, programs, derogations, including, of course, air quality plans and nitrate action programs and so on. But it is just, these are just examples. It should be all violations of EU environmental law and on national level also violations of environmental law that are flowing from national provisions. Things that to flag quickly, but this will be more addressed by Summer in some more detail, is standing. Standing under the Environmental Liability Directive, there has been the case in Folk, and Summer will cover that one quickly. And on individual standing, we had two cases, very recent, Morgenland and NRW, which clarify standing for individuals to some extent. But I will go directly on to the next chapter. And this is the final chapter relating to access to justice on member state level. And it implements Article 9.4 and Article 9.5 under European Union law. This is, again, an area that's largely based on EU case law, on the general principles of EU law and the Charter of Fundamental Rights, ECHR requirements. So we are drawing in this chapter together quite some different requirements from law and trying to explain to some extent what are the requirements. because these are areas that are largely governed by procedural autonomy for the member states. But nonetheless, there are principles that apply and that establish certain minimum requirements. Accordingly, the chapter goes through different topics, expected remedies, injunctive relief, timely remedies, costs, as well as also providing assistance to the public and informing them about the possibilities to bring an access to justice claim. I will not go through this in detail today. One case I wanted to highlight though in this area, because again, it's a very recent case, is the case in Deutsche Umwelthilfe. This one judgment just also came out last year, late last year, I think. And it concerned an air quality challenge. I mean, this is where the case started, and NOx exceedances in Munich that had led to a court order. My cat is just joining us here. Remove him. That led to a court order that the air quality plan in Munich had to be changed. But even though the court had ordered already fines at 2 separate occasions, the minister president of Bavaria stated that he would not want to comply with the administrative court order and would also not react to these fines being paid. So the question referred to the Court of Justice by the Higher Administrative Court of Bavaria was whether, in a case where fines proved ineffective because they were just paid from one section of the region to the other, whether it would be possible to order detention of the minister president of Bavaria. So the Court of Justice essentially held that this was not possible in this case. I mean, it was left to the national court, but it established very stringent criteria to detain a public official. But nonetheless, the court also spent quite some time to explain the obligation to apply coercive measures in such a case. And it emphasized the importance, also under the European Convention of Human Rights, that court judgments are implemented and followed by public authorities. And the court in particular highlighted the importance to apply dissuasive and repeated fines where necessary. So even though the main question essentially was a no detaining, but nonetheless, the court called on the Court of Justice called on the national court to apply whatever fines and other penalties it could within its national legal framework. And I think this is very important actually going forward, and also for other jurisdictions where at times court orders are not, at least not immediately followed by public authorities. So very interesting case. Then turning to a bit of a different topic, that's the last chapter of the guide, decisions of EU institutions and bodies. And those that have worked with the convention for a while know we had the very long communication before the compliance committee, Client Earth communication in C32. And this has led this year to an amendment of the applicable legislative framework. So what is the issue? On EU level, there are judicial avenues to challenge acts of EU institutions and bodies, but unfortunately, they are not available to actors, individuals, or NGOs that seek to engage in public interest litigation, that seek to enforce the EU environmental law. There's no direct access to the Court of Justice because these applicants are not considered individually directly concerned or directly concerned. And there's a possibility for national courts to refer questions, but this route is fraught with hurdles in practice. It requires a genuine national conflict. It is hindered by restrictive national standing rules and high costs on national level. It is hindered by national judges that are hesitant to refer questions to the Court of Justice, in particular in, I would say, in perhaps 2/3 jurisdictions of the European Union. And the whole procedure takes many years because the preliminary reference is added to the already very long national procedure. Because in particular, usually only the highest courts will refer questions. This has led to the establishment in 2006, a fact already acknowledgement of the issue of an internal review mechanism under the Aarhus regulation, which gives a possibility for NGOs at that stage, was only for environmental NGOs, to request an internal review within 6 weeks of an administrative act or an omission of an EU institution. And if the NGO received a negative reply to that request, could challenge it to the court, to the EU General Court. The problem with that system was that the definition of an administrative act was so limited that it applied in almost no cases, only in relation to specific chemicals decisions. And so it needed to be broadened. So this led to communication C32 and to a lot of politics that I will skip today. But finally, we had an amendment of this Aarhus regulation this year, which is, I think, a great success in itself. There were a lot of people involved in this, and also from the European Parliament, but also from the parties to the convention acting through the council that have made this possible. And this amendment, what will it mean? We have a new definition of what is an administrative act, and that means there will be internal review of all non-legislative acts with legal and external effects. So what are those? It is essentially all acts. There's a lot of acts adopted by the Commission that fall in that area, wherever the Commission has delegated or implementing powers. So we could imagine, for instance, the Commission decision approving a list of new fossil fuel energy infrastructures, that's the project of common interest list, would fall under that. Commission's decision regulating the driving emissions test that in some cases in the past had failed, should be possible. Council decisions to determine total allowable catch limits, perhaps possible. Decisions of the European Chemicals Agency's European Food Safety Authority. But these are just examples. It's essentially whenever an EU institutions or a EU body acts in a non-legislative capacity, so not when we are talking about adoption of EU directives or EU regulations, but whenever there is some form of delegation of powers. And the way the EU works, these are a lot of decisions in the environmental field. And so it's a major change that we believe will have a big impact for the work of environmental organizations and public interest litigation on EU level. There are still some issues to improve though. First of all, there has been now an amendment as well that gives standing for individuals, but the criteria that are imposed are very restricted. There's no possibility to change legislative acts. This is logical in the sense that it's an administrative review mechanism, but it will continue to be, it continues to be a lacuna, I think, on EU level in the access to justice field that needs to be flagged. And finally, as regards to the scope, it does not include Commission state aid decisions. And this will be something that Summer will be speaking to us about in the next presentation as well, because it covers the case C-128, which is the communicator. So this is was my presentation. I know I went a bit quickly because I wanted to at least cover all the scope, but I'm very happy to engage in more detail on any issues that you wanted to hear more about in the following discussion. But first, we will have another presentation. Thank you very much.
Thank you very much, Sebastian. Let me just, actually, I realized that I love to misuse my position as a kind of a facilitator of these meetings, so I can make comments while the others cannot. Basically, one thing that that came to my mind when you talked about the Umwelthilfe case is that I think the attention of ministers and especially prime ministers is should not only be possible, but it's also desirable. But maybe I'm biased by the fact where I'm from. The secondly is that I see some kind of a hidden race here, and I hope it's a healthy one that's gonna end up in the development of access rights between client Earth and Justice and Environment. Client Earth with the C32 case has already done a lot to improve access to justice. Now let's see what Ökobureau, and which is Justice and Environment Austria, can do via case C128. And the next presenter is Summer Kern. And let me introduce her. She originally trained and worked as an attorney in the US in the field of environmental and human rights law. Then she moved to Austria, where she lectured and worked as a lawyer for Ökobureau and Justice and Environment. And for 2 years, she worked as a member of the Secretariat of the Aarhus Convention, providing legal support to the Compliance Committee. So we will have information from an authentic source, I guess. And then she returned to Austria and resumed work with Ökobureau and Justice and Environment. So we are proud to have her in our small army of lawyers. So the floor is yours, Summer.
Great. Thank you. I will be right with you. Let me get. Don't know why I'm not getting my PowerPoint. Do you see that? The PowerPoint? No, not yet.
Yeah. On the
You do?
Oh,
You have it?
we're not seeing it at the moment.
Okay, thank you.
Shall I start it and then you?
Yeah, if you can.
Yeah, of course.
Because
Sure.
I got it first and it was just not going.
Absolutely, I can.
But if you can, sure.
Yes.
Thank you. Thank you.
Here it is. And
Perfect. I'm not as bad as Yerzy. Okay. So basically, as Csaba kindly introduced me, I'm Summer Kern and I'm a lawyer at Justice and Environment and Ökobureau. Next slide, can you do it?
Yeah.
So generally, I would like to discuss a few recent cases of the Compliance Committee. So recent that they couldn't be incorporated into this excellent guide that JNE and Client Earth built together. Saying that, I will not be talking about everything. So I really want to speak about certain challenges by the EU and judicial rights to challenge decisions when blocked by recognition requirements and individual use rights. And in doing so, I would like to highlight a few interlinkages with statements and rulings of other bodies, because in some of these areas, we have a clear case where these bodies are coming together, not just disagreeing with one another, but really agreeing. And finally, I just have to say that this is not exhaustive, this is not comprehensive. So I truly apologize to curators or communicants who have important, wonderful cases, and I'm just not going to talk about them. For example, time allowing, I would discuss cases about what is fair under Article 9.4 of the Convention and mention many other cases of interest, but I don't think we have time for that right now. Next slide. The first case, again, that I wanted to mention is C128. In a nutshell, it concerns the ability to challenge state aid decisions that are made by the European Commission. They have, under the treaties, the authority to say whether state aid is okay or whether it's not. Why is it important for state aid? Well, it can decide, they can decide whether a nuclear power plant can be built, whether major infrastructure can be built, and all of these sort of measures are not realizable without significant state aid help. So the Commission plays a very, very important role rule and says when that can happen and when it cannot. In this case, I should mention, I think it tails in nicely to Sebastian's conversation about the Aarhus regulation, and we welcome its adoption and its implementation of Article C32. Our case would have been a great opportunity to also implement those findings as well. But we understand more time may be needed on that. But indeed, my organization, Ökobüro, the Austrian wing of Justice and Environment, was the communicant in this case, together with Friends of the Earth Austria. However, Client Earth, the UK, and Friends of the Earth, England, Wales, and Northern Ireland were also very, very important in this case. So essentially, what was the problem? Well, these state aid decisions can have huge, huge impacts for environmental policy and projects that can hugely impact the environment throughout the EU. But also, this addresses sort of the more narrow question, narrower than C32. It's not just about a lack of access to justice, particularly, but a lack of access to justice to challenge the Aarhus regulation, which specifically excludes state aid decisions from challengeable acts. And this is also bolstered by Court of Justice jurisprudence, not just the famous Plowman jurisprudence, but also further rules relating to state aid that make it really, really impossible if you don't have a market interest, or if you're trying to just protect the public interest, you have no way to challenge these decisions. We argued that that was not acceptable. And essentially, the committee found this violates Article 9.3 and 9.4 of the Convention. Next slide. So I'm not going to read it aloud. You see Article 9.3. Those are the essential elements, not all of them, but the essential elements, and were at issue in this case. And so we, the communicants, and our excellent observers said, essentially, all members of the public are blocked. That's one of the elements of 9.3. We have no access whatsoever, another element. And we argued also, and maybe this was the hottest point, that no certain state aid decisions have the potential to contravene provisions of national law, in particular, for example, Article 11, which says that environmental concerns are to be integrated into any decision-making in the EU. 191, which deals with the environment specifically. 194, which deals with energy, but includes by reference issues about the environment. We said that those are all issues. They are provisions that could whereby a decision by the Commission could contravene provision of national law relating to the environment. So what was interesting, those were our arguments, we, the communicants and the observers. Next slide. It seems like actually we're not alone in that thought, because the Commission, in a staff working document that was submitted after a milieu investigation as to what the actual status is regarding access to justice at the EU law level, they created their own study, and afterwards the Commission made their own staff working document, their own report about this. And in this report, they said not only that Article 9.3 of the Aarhus Convention does not require that the challengeable act has an environmental purpose, but they made clear that the EU system of redress needs the scrutiny of all acts by the EU for compliance with Article 11 TFEU, which again is the integration clause by which every act or decision by the EU has to be made with respect or with acknowledgement of the environmental principles in the treaties. So seems like they sort of agree with us, actually. And what came on top of that is the Court of Justice in Austria v. Commission said specifically that Articles 11, the integration clause, Article 194, which deals with the energy requirements of the EU and includes Article 191 and other environmental considerations by inclusion, and any other rules must apply to state aid decisions. As a result of this, the Commission has to check that any state aid does not violate the EU law rules on the environment. And if it does, if the state aid violates these rules, it really has to reject them. Next slide. Thank you. So in our view, given the above, we really don't find any legal argument to deny this. Not after C32. After all, that's sort of established who the members of the public are, the lack of an ability to challenge that, for example, preliminary ruling procedures exist, are valued, but are not sufficient in order to attack directly decisions made at the EU level. And in fact, in the state aid rules, it's even more restrictive than this. So we have not only the Plowman jurisprudence, which some of you may be familiar with, but we have also a COFAS rule, and which is much more restrictive in this context and requires that a market, that basically the claimant has their position as a market participant has been affected. Now, that is not something that any NGO could claim. So we're left with, and I will leave this for another topic or a statement in the MOP, we need to find a productive way forward. And we see that the Commission is already committed to undertaking studies and roadmaps, and all of which are extremely positive. So we would like to engage in that process and leave political things aside. Next slide. The next case I would like to talk about concerns the effect of a very specific recognition criteria for having a democratic structure in Germany. This is one of many criteria, but this was the one that was specifically raised in this case. So what does it mean to have a democratic structure? Well, in this case, it means you have to have membership in the organization, but not just that, they have to have full voting rights. And why is this important? Why does this make a difference? The point is, under the relevant legislation, you need this recognition in order to bring legal challenges, for example. So NGOs like WWF, which is a foundation and has no members, and Greenpeace, which has members but does not have quick, easy voting, full voting rights to anyone who joins, they are completely blocked from any access to justice to challenge decisions under Article 9.2. Here we found the committee also said this violates Article 9.2 in conjunction with Article 2.5. the latter provision is about defining who is the public concerned. That becomes relevant because in the next slide, I can show you there's some takeaways from this case. So one first big question is Article 9.2, which is generally the provision by which you can attack certain very specific decision making. Usually it has to fall under Article 6. That if you read Article 9.2, and I've not put it here, it says that NGOs meeting the requirements of Article 2.5, which establishes who qualify as the public concerns, that's enough. That if that you have an NGO that meets the requirements of Article 2.5, there's nothing else. For an NGO, different than individuals, but for an NGO, that suffices to say you should have standing under an Article 9.2. The second point, and for me, maybe personally, the most important one, is that NGO work to protect the environment is not a popularity contest. This may sound a little bit trite or silly, but the idea is the work that we do is not popular. It may never be popular. If we're very lucky, we happen to be located in a country where it is popular and people support us and we have no problems about data protection and everybody helps us. But generally speaking, that cannot be a given. Think about countries like Poland, Belarus, Hungary. Are we popular? Are NGOs protecting the environment popular? Can we show that? No. And even in my country, Austria, I think that can be a bit problematic. In this regard, I would say consider Tugaden, sorry about the pronunciation, and the wonderful, wonderful opinion by Ms. Sharpston, the AG Sharpston opinion on that case. So if you read that case really carefully, I don't think that you will see anything about there being a need for popular support or even a membership requirement. I can cite to you, if you want in the questions, the paragraphs that I have in mind, but honestly, I just find no basis in either that Court of Justice opinion nor the opinion of Ms. Sharpston for this idea that popular support is needed for an NGO to have standing, despite what is commonly claimed in various circles and in the literature. Next slide. My next case that I would like to mention to you all concerns individual standing. So this was an individual who sought to challenge a ministerial order. I can, in the question period, explain more about this, but essentially this individual was denied standing, despite the fact that he argued, well, there are certain provisions in international and national law regarding the right to participate and initiate proceedings against certain decisions that can affect the environment. He also participated in the legislative procedure that led up to the challenged order. And he says, generally, he has an interest in wildlife and its preservation. In this case, the committee found no violation of Article 9.3 for denial of standing. Next slide. In doing so, the committee made a few really important points. First off, they reiterated that, contrary to what is often said, there is no actio popularis under the convention. So that does not mean everybody gets access to court. And they also recognize there's a difference between individuals and organizations, NGOs. And then secondly, the factors raised by the individual claimant in this case, that he had participated, that he was interested in environmental issues, etc., that was not enough to establish standing under Article 9.3 of the Convention for an individual. The point that I find the most interesting, and it's really vague, it's not clear, but there's some dicta there, is that there's a mention of use rights. I don't know how many people know about use rights, to my knowledge, but I recommend, I welcome questions and commentary if I'm wrong, but to my knowledge, this concept of use rights has its genesis in Sierra Club v. Morton, which is an early United States case. In that case, the NGO Sierra Club, the oldest NGO, environmental NGO in the US, was denied standing. But in a very small little footnote, the court, the Supreme Court of the US said, well, perhaps if they could establish that their members went hiking in these regions that they were trying to protect, maybe that might be enough to establish standing. And that, in the US, I can vouch for it, that little footnote took hold and is really established. It's used, it's big. I didn't see it in Europe for a long time. The first time I maybe noticed it, I don't want to jump ahead, was with the Gert Volk decision from the Court of Justice of the EU, which concerns the rights of a fisherman. But to go back, that we only had Gert Volk, to my knowledge, in Europe. But before that, we had the Commission's Notice on Access to Justice, which I believe was published in 2017. And in that, it says that it recognizes that there are use rights in nature. They can be recreational, maybe even research rights. And that can be a powerful tool. And since then, after that, as I said, there was the Volk decision, and since Burgenland and North Rhine-Westphalia, I can give the specific citations to these. We see the recognition of use rights in clean water for drinking or for other uses as being legitimate and giving standing. So this is another very exciting, interesting application of that. And most recently, I believe in Ukraine, it's Supreme Court. I believe the case was dealing with the rights of access to water, because there was a hunting association which had fenced around a body of water, which would prevent bathing and fishing and other uses. And the Ukraine Supreme Court rejected that, saying that there are general uses for the water for people, and it should be acknowledged and continued. So just a closing remark on that. Ways forward with use rights. Well, I mean, first off, as it's been applied in the Court of Justice of the EU, to my knowledge, correct if wrong, it's mostly been dealt with in water law, and it's not been used by NGOs. So what I think the Commission's Notice on Access to Justice says, and what I think also the genesis in Sierra Club v. Morton and the experience from the US says, is that it can have a much wider application in terms of the scope. So it could be hiking rights, it could be rights in nature, have just people enjoying nature undisturbed, But I also think that one should think about not only individuals bringing these cases, the fisherman, the hiker, but rather, as it started out, the members of that particular organization asserting that right on the behalf of the NGO. So I think that there's much to be said and explored in that area. Next slide. I think I'm running out of time, and I would really, really welcome any questions. So I think I will not talk a lot about this, but I just wanted to flag for you that, again, this is just a sampling of a few interesting aspects of new jurisprudence coming from the Compliance Committee, and but there's quite a bit more. So fairness, the idea of fairness under Article 9.4 of the Convention is just one example. In this case, I would highlight, for example, in C90, UK, the committee found that it was not in line with fairness under Article 9.4 that developers have access to a full merit review. That is, they have a level of administrative review, and all other members of the public have no such access. That is, the developers, if they're unpleased with a decision against them, they can go to an administrative level of review, and it's a full merits review. And then if they don't like that, then they can go to the court. In the UK, other members of the public, NGOs, what have you, they cannot have access to this particular administrative review board. They have to go straight to the courts, which have the problem that they're quite expensive, but also they have a more limited scope or standard of review. And this is just does not seem fair. So the Compliance Committee said, this is problematic. This is a problem in view of the requirement under Article 9.4 that procedures be fair. In C131 UK, it's actually an issue which came before the Compliance Committee already, but it's just come back again. It's about the time limits to bring judicial review. Like, does the time limit start to run from when the decision is made, or when, for example, do the parties have reason to know about that decision? And I think that's, for claimants in that country, a very significant issue. And finally, and I'm sure we will hear during the MOP much more on this subject, costs issues seem to be a very, very significant aspect of fairness for claimants in the UK. So with that, I would really like to thank everyone very much, including Csaba, for helping me with my slides. And I welcome any questions.
Thank you, Summer. Actually, my pleasure. And I think this is the time for questions and discussions. And maybe you are already burning inside to ask questions, but before that, let me just mention that I especially detected two very interesting points. Apologies, Sebastian.
Apologies, I just muted you by mistake.
You muted me. Okay.
By mistake.
By mistake. Aha. Okay. Okay. I said there is this kind of competition or healthy race between clientors and justice and environment, but it doesn't mean that you can mute me when I'm speaking. Okay. Okay. We'll talk to you later. Okay. Stay here. So to finish, both were in Summer's presentation. Apologies, Sebastian. One of them was use rights. I find it a bit strange to my continental thinking. If you're not an owner of something, or you don't rent a place and you don't live next door, then why are you claiming that you have anything to do with, I don't know, landscape? Definitely, I support use rights. I was just trained differently. And the other thing is the C-128 case, and I am probably not revealing a secret. But Sebastian, just mute me if I'm revealing a secret, okay? You have a you're so experienced in muting me, so that we can expect very lively moments next week during the MOP. And if people are more interested in what we can expect, I think my colleagues can share some information with you. And maybe refresh your memories what happened 4 years ago at the MOP 6. So this is kind of an appetizer for starting a debate. Sebastian, I don't know, can we unmute the participants? Okay, because all were muted.
I believe everyone should be able to also unmute themselves now. That was my technical attempt that led to me muting you just now.
So the participants can unmute themselves, and now this is the time for speaking. We're really looking forward to your comments, questions. Okay, we have already a question from Ben Chrisman. Hello from Scotland. Summer, what does the Article 9.4 requirement for fairness mean? The ACCC did not seem to give much in the way of reasoning on this. Summer, can you elaborate a bit on that?
Yeah, I think so. So I think there were a few fairness issues, but the main point that I was trying to make, which I understand, I think unfortunately the curator can't be on. As I understand, she's actually delivering a talk herself in parallel, but I would love to hear what she would have to say. But the fairness requirement that I wanted to make about C90 was they thought it's unfair that the developers had this access to an administrative review procedure, which is cheap and which could undertake a full merits review. So I don't know how much of everybody is here a lawyer, but that means, you know, they look at the whole picture. They can open up and look at the administrative files, and they don't say, oh, the administrative authority said that that was enough, so that's fine, we're not going to look at it. Whereas other claimants, those NGOs or individuals who would like to claim, challenge this sort of decision, they had no access to this administrative review procedure, but had to go directly into judicial review, which to my knowledge, correct if wrong, to my knowledge, in the UK and Ireland, is extremely restrictive. They have a very strict standard of review, and it's very expensive. So I think the compliance committee was thinking, well, it's unfair probably in multiple reasons. One is the developer, you know, has this whole system, administrative review system, and they don't have to pay a lot for it. And that administrative review procedure will really, really look into the details about everything. Whereas the courts will not. And the courts tend to be very, very deferential to the administrative bodies that undertook the original decision. So I think that these two things in particular were I don't know. I was not party to this, and even if I were, I obviously cannot talk about internal deliberations. But I can honestly say I was not part of this. The idea that you have an entirely separate, very cheap, very in-depth judicial review procedure for developers that is not available to other parties was problematic. And yeah, because it's expensive. So most people in the UK, Northern Ireland, they just can't afford them. And yeah, the courts are just not really looking at the issues. So it's different. For example, in Austria here, we have a situation where the courts, we don't have anymore. We did before, but we don't have an administrative level of review. You go directly to the courts, but the courts have a lot of power to say, I don't like this expert report. I don't like it. I don't think that there's enough there. And they can request a new one. And I think that's not generally done in the UK. So I think these two reasons, they thought that was unfair for claimants in that case in C90.
Thank you, Summer. And actually, you cannot relax, because there's another question again to you on use rights. Thank you. It came from Jacqueline Minard. If user rights are to be recognized more in the future, would that be helpful for a civilian in a polluted air area or a river or nature reserve with own standing? I guess yes, but let's hear the details.
Absolutely. Yes. So I mean, I don't think that this is the only way that we should go forward. It's a very anthropocentric approach. I think it's great if NGOs just are recognized, period, as having the right to protect nature. And we don't have to, in an ideal world, I think it would be great if we don't have to use these use rights in order to protect nature. We just say we're here to protect nature. But either for NGOs trying to expand their rights, and as I said, I think this is a way NGOs should also use rights, but also for those who are civilian in a polluted area or a river, absolutely, you should use that.
Maybe I can add something. I mean, absolutely agree with Summer. 2 points I think to make on that is, on the one hand, I mean, now we have the Court of Justice judgment. Both of them, as Summer mentioned, are from the context of groundwater pollution. I will speak up as I see perhaps I'm not loud enough. Groundwater pollution, so specific actors that were legitimately using the groundwater. And I think now it's about, the question is about how will this be applied in other areas in relation to other environmental factors. We as an organization have a number of cases on national level relating to air quality. We were trying to always include now the argument that there's also, based on the legitimate use of local residents of the air, that this case law should equally apply and give them standing. So we hope that we get a Court of Justice judgment anytime, I mean, within the next years, that could support such a more expansive interpretation. And we think that would definitely be very, very helpful with developing individual standing in the European Union. And then on the other hand, I think it's also important to contrast this very progressive statements from the Court of Justice with the outcome of the legislative procedure that we just had on the Aarhus regulation, where we also made the argument, look, this is what the Court of Justice just said. It has referred to legitimate use, but this was not yet acceptable to a majority in the council. So the criteria for internal review under the Aarhus regulation for individuals are very restrictive. Needs to be a big group of citizens. that gets together and is from different member states, and then it joins to bring that into a review case. So there's a very high threshold of representation. So just the legislator has taken a very different approach there. So I think there's still quite some way to go, and to get this kind of shift in the thinking, because I think, as Chaba mentioned in the beginning, it's quite alien perhaps to also lawyers on the continent, but it's really a very necessary legal development.
Yes, fully agree. Anyone else with a question? If not, or you're just thinking about formulating a question, let me just, oh no. It has priority. What's your view on the methodology applied by the Compliance Committee in case C-137 in analyzing whether the stated reason for the membership with full voting rights criteria was in compliance? It seemed to apply a more articulated analysis and an implicit proportionality test, and it shifted the burden of proof onto Germany to show the criteria was justified. Summer?
I can speak on this, Sebastian. Do you want to speak first to that?
You can go ahead. It was part of your presentation. But otherwise, I can start. So C-137, for everyone less familiar with it, Summer has just covered it to some extent. It is concerns the criteria for environmental association to essentially bring claims to become registered in Germany. And the at stake in the communication itself was only one specific aspect, which was the what would be called the democratic representation. So to say what were the that an organization has to have, the members have to have voting rights in order for an organization to then be able to go to court. And so as to the justification, the question concerns the justification given by the compliance committee in relation to this finding. So there has been, I think, some criticism from the party itself of the rationale as well. There was, I think, also reflected in the comments on the compliance committee's findings that it would be going too far. But in fact, the findings, I believe, are quite limited in what they say. They are not of particular far reach. It is, I think it's fair to say, perhaps you're saying here, there is an implicit proportionality test or a need for Germany to justify that the criteria were justified. I think that's correct. I think it is on the parties to the convention to explain how the criteria that they apply do not unduly limit the possibilities for NGOs to go to court, that their access to justice rights are effective, and at the same time to demonstrate that any criteria that are applied are fulfilling a legitimate purpose that is inconsistent with the convention. So it's not that the parties to the convention are not able to apply any kind of criteria. I think a criteria exists in all parties to the convention in relation to environmental NGOs. Environmental NGOs usually have to show that their statutory purpose is in line with environmental protection, and there can be registration criteria, and there can be other methods applied by member states to make sure that the applicants are indeed genuinely non-profit organizations that are interested, they're working for environmental protection. But then there are other criteria that are excluding organization on in this case, I don't want to use the word arbitrary, but on a basis that leads to the fact that a lot of the actual organizations that will be able to bring cases are very limited. And I think this is the same of the rationale, in fact, in the Tiergarten case in front of the Court of Justice, where it was speaking about the criteria applied by the Swedish administration or the Swedish law. Back then, there was a requirement to have 2,000 members. And the court also said this is inappropriate because it will exclude all smaller environmental organizations from going to court. Now, Sweden has changed its criteria, and it's again in front of the compliance committee because of the new criteria. This is a pending case because the new criteria essentially you have to have a lower amount of members or alternatively show public support. There, it's not clear how you can show public support. So again, there will be another discussion on that. But just to say that I think the underlying rationale there is the same. If your criteria are excluding specific organizations without that being justified for the purpose that is consistent with the convention, then these criteria should be changed. And there's clearly an obligation on the parties to justify that. So I guess we can speak about a shift of the burden of proof in that sense.
Thank you, Sebastian. Summer, do you want to add anything to this?
No, I agree with everything Sebastian has said. Also, I also agree. I think that the compliance committee's findings, they had a lot of information before them, but the communication itself was rather narrowly drawn, dealing with this particular democratic structure requirement, one of many requirements to achieve recognition under this provision. And I think the committee therefore sort of stayed within that boundary. So I think it's actually a rather conservative case. And as far as any shifting of the burden of the proof, yeah, I mean, this you can also, please excuse me if I missed something and I'm just repeating what you said, Sebastian, but they were not being new. This is no new development in the compliance committee's jurisprudence. This is all from the criteria that they set out in what, C31, Germany? I mean, so you know that the criteria can't be unduly burdensome, so that they have to be fair, etc., etc. That's all there. So there's nothing new in 137 about that. So they use their old jurisprudence to just look at this very, very narrow individual criterion and say, yes, we have a problem with that. And indeed, the Tiergarten case, I mean, I have quotes from the judgment, I have quotes from Sharpston. I think it's pretty clear to me that if you go beyond, you know, forget about the democratic requirement, if you look just at the membership and other potential requirements for NGO recognition that have the effect that they may have limited participation and access to justice rights. I think that showing that you have an environmental purpose and are a legitimate NGO should be pretty much enough. End of story. And it's not there because it wasn't there before the committee. But I think if you really read the Court of Justice opinion, if you really read Ms. Sharpston's opinion, I think it's there to see.
Thank you. I think we have a time for one last question. And maybe that question will come from me if no one else is interested in asking one. Summer, you said something which was not related to any compliance committee finding, but really struck me that previously there was an administrative review in Austria and now there isn't. So once there is an administrative decision, you can only go to court right after that. I mean, very suspiciously, the same thing happened in Hungary just a year ago, then we got rid of the administrative review. And I'm interested. I mean, we are here now, almost 40 people from different countries, whether this is a trend that the administrative review is getting more scarce. And the secondly is that once you go to court, you have to prove your point, of course, but then at the court, you will need to have either a court-appointed expert or a private expert, which really raises the cost. Instead of having the case go through two instances or two levels of administrative review, which includes definitely expert review within the administration. So that's all that I'm sure it's going to bring up cost issues as well. And just a footnote that I'm worried because in Hungary, I see this as part of this rule of law problematic, which you may be familiar with. So I see it only as a brick in the wall that that fits very well into the government's anti-rule of law rhetorics. That just one less remedy here and one less remedy there. I don't know what you think, and not just you, Summer, but everyone, what you think about these issues.
Okay, with the caveat that I am not the leading Austrian expert. As you said, I'm originally a US attorney, but my understanding is, for example, so we abolished, there was an environmental Senate, which was not necessarily independent. And that was considered to be not in keeping with the European Court of Human Rights and was abolished in major reforms that took place in 2014. So now everybody needs to go to court. However, at the first instance in the courts, you don't have to be represented by a lawyer. And all of us, we don't count as lawyers for reasons I will not explain. It's not like the situation in Germany or Hungary. I mean, to get acknowledged, I'm an attorney in the US, but I am only a lawyer in Austria. And to get recognition as an attorney and be able to go to court is something different. So you don't have the attorney costs at the first level. However, this issue about having expertise is a huge problem in Austria. But I think it's probably been a huge problem even before they introduced the new system. So I think there was no way you could ever attack an EIA or major development project without engaging and paying 5,000-10,000 euros for an expertise. Quite apart from the legal fees. And so I think that has actually not changed for us, to my knowledge, even though we no longer have this administrative review level. And I have to add, actually, it's caused major problems for us because we now are under the court rules, and they say, you know, if you're bringing up a certain issue, even if you're not the project developer, if you raise an argument and the court of its own motion decides this needs to be investigated further, the court has the power to appoint and have somebody do their own investigation, and that can be 5,000-10,000 euros. And then that can come and has come in a major prominent ELD case on us. Even though that's not the way the ELD was considered, that's not the idea behind it, but so expertise, that's a big problem. For us, getting rid of the administrative review level is, I think, for that, it's not so problematic, but the problems just get pushed onto the court level. If that answers your question.
Yeah, so definitely that answers, and the same here. I mean, it's obvious that that's going to be the consequence of these changes. Okay, our time is up, and it's my time to thank all of you for participating and staying with us for the whole duration of the presentations and this side event. Thank you for the applause. Thank you so much. And what I can suggest you doing is following the websites of both Justice and Environment and Client Earth. Sebastian, the video will be available, I guess, on both websites. And just once we say goodbye, of course, we are here to answer any of your questions. You can find the contact information in the slides. And again, thank you very much for your participation, and have a nice rest of the day. Thank you. Bye-bye.
Thank you, Csaba. Thank you, Sebastian.